Hello, scholars. This is Garrett Kepping, and today we're going to be discussing a wrinkle in our criminal justice system called the exclusionary rule. It is unusual. I don't think I'm not sure there's any other country that has the exclusionary rule like we do. So let's talk about it today. When we talked about criminal process earlier, the criminal procedures that we have in the United States, I had mentioned that if evidence was gathered illegally, that evidence is then going to be excluded. So this comes from something called the exclusionary rule. And one of the challenges with the Fourth Amendment right against search and seizure and the Fifth Amendment right about coerced self incrimination is that what if the police violate those rights? What if the police search your house without a warrant? What if the police coerce a confession? What happens to that evidence that was illegally gathered? So we've been struggling with this for a while now. If we want these guarantees to be real, we need to have some sort of way of discouraging the police and law enforcement from violating our rights. How do we do that? So one option, of course, is, and this is what most of the world does, is they still use the evidence. So if you're in France or something and the police illegally search your home, or they coerce a confession, they can still use that evidence. Now, maybe the police officer will get in trouble, maybe they'll be disciplined, maybe they'll be fired, but the evidence is still going to be used. And the problem is, does that create enough disincentive for the government to not violate our rights? Now, the other option, of course, is we forbid the evidence to be used, what we call fruit of the poison tree. That if the evidence is gathered illegally, that evidence can then not be used in court. Now, the downside of that is criminals will get away with crimes that we knew they did. And obviously, in some of these cases, some of these famous cases, say Miranda versus Arizona, where evidence was excluded, these are serious charges. These are violent and dangerous criminals that are essentially getting away with it because the police violated their rights. So in the United States, how we've come down on this is that basically what we'll do is we exclude evidence illegally gathered. And that's the determination that we call the exclusionary rule. So again, the exclusionary rule says that evidence gained is the result of an illegal act by the police cannot be used at the trial of that person for whom it was seized. So if the police illegally search your home, they find, I don't know, an illegal gun, that evidence of the illegal gun would be suppressed because it was illegally gathered. And the idea then is then the police will be better about protecting our Fourth Amendment rights. The downside, of course, is that the defendant will have gotten away with the crime. Now, the first time we see this, the exclusionary rule established is a case called Weeks v. United States. And in Weeks, it was a federal case. It was a narcotics case. And in Weeks, again, the police basically illegally obtained evidence. That evidence was then suppressed. But what makes Weeks of limited impact is that it only applied to federal law enforcement. And then, as now, most law enforcement is at the state level. It's the state and local level. It's not at the federal level. So Weeks established that the federal government, federal law enforcement, needed to protect our rights. And if it didn't, that evidence would be excluded. But it's important to remember that federal law enforcement, there's not actually a lot of federal law enforcement out there. Most law enforcement is at the state and local level. So when the exclusionary rule applies to the states, it's a really big stinking deal. And it happens in the case of Mapp versus Ohio in 1961. Now, the fact pattern of the Mapp case is sort of fun / disturbing. Basically, the police become convinced that this gal, I think her name was Dora Lee Mapp, was hiding a bombing fugitive, somebody who had made a bomb for the mob. They wanted the police wanted to go inside. Mapp refused. The police forced their way inside without a search warrant. Mapp decided to demanded to see a warrant. The police lied, said they had one, and then they sort of waved a piece of paper. She grabs the piece of paper and they actually wrestle for the piece of paper. Eventually, they extract the fake warrant. They then arrest her, and then they basically tear the house apart looking for any sort of evidence that they can arrest Mapp for. And I think in the attic, they find like a suitcase that had been owned by a previous renter. And in the suitcase was some pornographic books. And so they arrested her for the pornographic materials. This is before, and there's going to be another case we talk about later involving pornographic materials. So the outcome of MAP is a 6-3 ruling that basically says that now if the state police, county police, local police, if they illegally gather evidence, that evidence will also be excluded from trial, meaning the jury won't even hear about it. And obviously, if you're throwing out really critical evidence, that means that basically the prosecution is dead. You can't go. With some, like, let's say it's a possession of drugs case, and you throw out the evidence of possession of drugs. Well, then you're not going to really have much of a case left after all. Now, as time has gone on, there have been some exceptions to the exclusionary rule, and those exceptions are one of the big ones is called inevitable discovery, and it comes out of this case of Nix V Williams. Now, again, remember that a lot of these cases are really quite horrible. So when we talk about the exclusionary rule, we have to remember that some of these people have done really horrible things. So in Nix V Williams, Williams is arrested for the murder of a 10-year-old girl. He had killed her and disposed of her body basically in a park. And he had made no effort to really conceal the body. He had dumped the body along a gravel road that was not widely traveled, but was occasionally traveled. He had made a statement to the police without being properly Mirandized. Basically, he had made a sort of a confession, which the way the police did it had been inappropriate. And so during that statement that he had said, that Williams had said, that statement that led the police to the body had all sorts of evidence that then led to the arrest of Williams. So the question is, well, if the interrogation that led to the body is illegal, doesn't that mean the body itself, the evidence on the body, is also then subsequently illegal? And what the court said was no, because the child's body was in a basically semi-public location, and inevitably the body would be found. For that reason, the evidence could be allowed. So if a person has evidence in a semi-public or public location where that evidence would have inevitably be discovered, then the evidence will be allowed. Now, how much impact Nix V Williams has? Most criminals, when they commit crimes, make some reasonably credible effort to hide the evidence, right? They don't leave the evidence lying around. So Nix V Williams is not really revolutionary in terms of weakening the exclusionary rule, but in some cases it does mean that the evidence would be admitted. Now, a little bit more impactful is what we call the good faith exception, which is basically if the police tried their darndest to protect your rights, and there was just a mistake, right? Maybe they put the wrong number on a warrant. Maybe they got information from a previously reliable informant who ends up being unreliable in this case. The police are doing their darndest to protect your rights, and sometimes just mistakes happen. Well, then the courts will allow that. So this gets established initially in this case called US v. Leon in 1984. Basically, again, the idea is if the police were trying to do something, they're trying to follow the rules and they failed, the evidence will still be allowed, because after all, the whole point of the exclusionary rule is that the police are going to protect our Fourth and Fifth Amendment rights. And if they're trying to do that, then the courts may allow that evidence. Again, in Maryland versus Garrison, we have sort of a variation of the good faith exception, which is honest mistakes. Very recently, there was a case before the U.S. Supreme Court where the question was, if the police pull over your car because they think there is a violation, and basically moving violation in the facts of the case, I think it was out of I don't remember the state, but it was a situation where the police pulled somebody over because they only had one working brake light. And the police officer mistakenly thought that was a violation. Well, in fact, under state law, it wasn't a violation to have just one working brake light. So the officer incorrectly pulls someone over, ends up finding evidence of, I think it was drug possession, arrests them. And so went to the Supreme Court and said, well, what if the police officer sort of made an honest mistake in pulling somebody over, thinking that there was a traffic violation when really actually there wasn't a traffic violation. And in that case, the court said, yeah, that's allowed. We'll allow that evidence. Because again, there's no evidence that the police intended to violate your rights. They just made an honest mistake. So the good faith exception or the honest mistake exception, this can be a little bit more germane to more cases because there's more of a possibility that something like that could occur. So this is the exclusionary rule and how it applies. Again, in some ways, it's a very simple concept. Next time we meet, we're going to talk about the Fourth Amendment search and seizure prohibition, and we're going to or protection, and then we're going to talk about self-incrimination. So have a lovely day. Have a good day.